Right, we are live. Hello, Dr. Kilfoyle. My name is Riley Hamilton, and today I'm happy to present to you my submission for the Module 4 Assignment 1 pertaining to a notable court case in education. The case that I chose to investigate was the Endrew F. versus Douglas County School District case being finalized in 2017, and it is one that was escalated through two lower courts all the way up into the Supreme Court of the United States. This caught my attention, as did the analyzation by researchers and public opinionists, which suggested that this case may have just completely revolutionized the individualized education program procedures in their entirety. We're going to go ahead and start by taking a bird's eye view of the case, what had happened, and eventually led to its escalation to the highest level. And we will start by discussing the background of the learner at hand. Endrew F. was a student that was diagnosed with autism at the age of 2 and entered into the Douglas County School District in preschool and eventually exited in the 4th grade. He was exited as his parents were not satisfied with the progress that was being made, and they eventually decided to enroll him into a more privatized instruction environment where he would receive instruction to meet the needs that were presented to him by his intellectual disability. Endrew started to really accelerate through the program and show terrific progress. And for the reason being, his parents decided that the education that was served to him in a prior school district did not exactly meet the definition of a free, appropriate education. For the reason being, and for those fees that were associated with completing that program, they decided to seek restitution, as he had some tuition fees that the family just simply could not afford. They filed a complaint under the Individuals with Disabilities Education Act through the Department of Education in Colorado. This claim was denied at the first level court in a federal district court in Colorado and eventually denied for a second time in the 10th Circuit Court of the United States. The reasons being we will discuss at a later time, but it ultimately had to do with a definition that was provided in a notable case, that being the case of a student, Amy Rowley, which was finalized in 1982 and was finalized on the premise of a definition of providing a free and appropriate education, as they had suggested that he had made some progress. Now, the parents were not happy with the progress that was made, and that ultimately ended up forming the basis of their case. The family of Endrew F. was represented by Jack Robinson, who won Advocate of the Year award by National Disability and Rights Group, that being the ARC. And the premise for their case was that they interpreted the definition that was provided for a free and appropriate education as one that provides an educational opportunity that is noted is substantially equal to those opportunities that are afforded to children without intellectual disabilities. They felt that he really needed to be being on the same playing field and meeting those and having his needs met to the same of those students in the general education classroom. Now, when we consider the case that was presented by the Douglas County School District, they found their justification in relying on that former legislation that had been passed in 1982 in the case of Amy Rowley. And they interpreted the definition of a free, appropriate education as one that provided the student with a quote unquote meaningful benefit. Now, in some research that I did collect, it is suggested that these decisions at the lower courts really fell into two categories. One category that stood out was that first initial example of the student had been served an education and was provided with a meaningful benefit. Other definitions that were construed, or you could say misconstrued, of the definition of a free and appropriate education had suggested that it only was required that these students receive some benefit. I did listen to the court case, which was an hour long on YouTube, and I tell you what, just listening to the some benefit, this benefit, they actually did make some jokes about it, and the court actually seemed to have kind of generate a uproar of laughter because of this confusion using these terms over and over. So with this disagreement at hand, it is important to consider how they got to this place to begin with, and how that definition of a free and appropriate education was constructed. We look now to a case of a student, that being Amy Rowley, in a case between the Board of Education of Hendrick Hudson School District versus Rowley, and taking place and being finalized in 1982. Now, Amy Rowley was a student that was deaf and was receiving services through that school district. And in a similar situation, her parents did not necessarily agree with the services that were being provided. To kind of talk a little bit more about that, Amy was deaf, and the solution that was presented was to provide the student with a FM radio headset to where she could receive the input from the teacher. But there's just one problem with that. The parents decided that she should be receiving sign interpretation services. Um, and ultimately, it was decided that at a lower court that they agreed. They supported the notion that she had not been supplied a free appropriate education, but this case was eventually overruled by a Supreme Court decision that these students are not necessarily entitled to services that are going to maximize their potential as long as they are provided services that are reasonably calculated. Now, we will kind of discuss the implications of this at a later time. Um, but one reference that was made that was extremely interesting to me was the provision of an education that is quote unquote not providing services that are a Cadillac or a Ford Pinto, but rather one of a Chevrolet Impala, suggesting and going back to this definition of free appropriate education that as long as they are reasonably calculated for the student to receive benefits, then they are doing their job. They are doing their duty. To go back now and having that background history and to revisit the case of Endrew F., the court ultimately took a decision that I really was not expecting. I really was not sure what to expect, but the court actually suggested that a new definition be provided for what it means to provide students with a free and appropriate education. They changed the definition and made the case that an IEP must be reasonably calculated to enable a child to make progress appropriate in light of the child's circumstances. We will talk a little bit more about how this will affect education. But overall, it is suggested that this must be challenging enough that the student is going to be able to or to make significant progress, and the plan must be tailored and specific and unique to one learner. It cannot be one that can be applicable to any other learner. It must be in light of the child's specific circumstances. There are some suggestions as to what this looks like now in the field of education as a result of this ruling, and they are as follows. I was able to consider some public opinions and kind of provide some of my insight as to what I think this might have to do with in the future and how this might affect education, and we will talk about those. It is reported to in an article that I found by Hecht in 2017 that all staff must have the tools and professional development necessary to create an inclusive classroom where all students, including students with disabilities, can meet their educational goals. Um, right off the bat, an implication that is suggested there is that this is going to cost some money. This definitely makes some connections to some prior projects that I have completed in this course having to do with how educational facilities, school districts are funded. And right off the bat, I can see how that might present an issue just because we know through evidence that is supported in research that not every school district is funded equally when considering other school districts. And for the reason being, this could definitely pose an issue. These educators need to be prepared to serve these learners. These IEPs are a living document. They are changed every single year, and these educators may be put into a position where that student receiving certain services may change year to year. And for the reason being, those circumstances that the child is being served under in those particular circumstances may change. And therefore, they need to have access to resources that can meet these changes as they are documented. So right off the bat, money definitely was one thing that I was considering. Another thing that I was considering, based on the opinion that students with special needs can continue to meet the demands of their IEP designed to tap their particular potential to make reasonable progress towards realistic educational goals. This kind of had to do with a connection in the last unit of curriculum and law associated with it. I found some connections with providing students services that will not leave any of the children behind. And this is going to really result in having teachers that are better prepared to serve these students, high quality teachers, and those that are adaptive and able to meet these needs. All in all, I would say that this case was revolutionary in these senses and also is one that is definitely going to have some effects on curriculum as the educators are needing to consistently be sure that they are meeting the needs of these students and having all the necessary functions and equipment and resources available to do so. These are some of the references that I considered in formulating this presentation, and I'm happy to provide other ones if need be. So, thank you for taking time to review this, and I hope you have a wonderful weekend.